Madam, you can start, I think. Shine, madam?
Yes, sir.
Yeah.
Am I audible, sir?
Yeah, you are audible.
Okay. Thank you so much, sir. Good morning, everyone. On behalf of the AIKTC Central Library, I, Shaheen Momin, extend a warm and heartfelt welcome to all of you. Today's session is being held in celebration of two significant events, that is World Book and Copyright Day and World Intellectual Property Day in collaboration with IQAC of AIKTC. This event is an initiative to raise awareness about the value and the protection of copyright and IPR, especially among our young researchers and faculty members in a world driven by innovation and creativity. It is vital that we not only create and discover but also understand how to safeguard our intellectual contributions, whether it is writing a book, publishing a research paper, or filing a patent. So, before begin this enlightening journey into this webinar, I now request Mr. Zaid Bakshi to bless this occasion with the recitation of the Holy Quran.
Assalamu alaikum. Am I audible, ma'am?
Yes, you are audible, sir.
Okay. Bismillahirrahmanirrahim. اقرأ باسم ربك الذي خلق خلق الإنسان من علق اقرأ وربك الأكرم الذي علم بالقلم.
Jazakallahu khairan kasira. Thank you so much. Zed. Now I take the honor of inviting Dr. Rajendra Magar sir, the Dean of School of Engineering and Architecture and the coordinator of IQAC to address the audience and formally inaugurate today's sessions.
मैडम खटिक सर है क्या? देखो खटिक सर ज्वाइन किए क्या? देखो
हाँ सर ज्वाइन
Yes,
किए वेरी
अच्छा सर
just joined. Yes. Thank you, sir, for coming on the holidays. So now I request our director, Dr. Ramzan Khatik sir, to address the audience and formally inaugurate today's session.
very good morning. I welcome all the participants, experts, resource person Ms. Sheetal Dube and the resource person from the AIKTC, Dean Dr. Rajendra Magar, others deans Dr. Shari, Professor Raj Matre and all the heads of department from School of Engineering and Technology, School of Pharmacy, School of Architecture and outside participants. We are celebrating the IPR World Day in collaboration with our Central Library, Knowledge Resource and Centers and IQAC of AIKTC.
Thank you, sir.
सर की आवाज थोड़ी सी कट हो रही है.
हाँ, I think.
ओके मैडम, यू कैन. आई थिंक सर का हो गया एड्रेस शायद.
So, sir, now I request you to please brief about the basic objectives behind this webinar to our audience.
Good morning to all of you, dignitaries present over here. We warmly welcome all the participants for this important webinar on copyright and IPR awareness, joint celebration of World Book and Copyright Day. Actually, it was supposed to be celebrated on 23rd April and 26th April as a IPR Day. But we know that we are the academicians and University of Mumbai and other university also have examination on, particularly the Viva was
Magar sir, please unmute first.
Sorry.
Yeah, you are unaudible, sir.
Okay. Sorry, I will repeat.
Okay.
Yeah. I warmly welcome all the participants for this webinar on copyright and IPR awareness, joint celebration of World Bank and World Book and Copyright Day. Actually, it was supposed to celebrate on the last week, but we know that we are the academician and we are working under the University of Mumbai and other university. Some participants are also from out of other universities. A very busy schedule related to the examination. The Viva exams were on from 21st April till it is going on, and as well as theory examination of University of Mumbai will start from the 13th of May. So everyone is busy in the preparation of the exam. So we could not conduct this program on the offline mode, but very short period of the time we decided he will go on the online mode, and because NAP wants that hybrid mode, few of the events should be conducted of the online mode, and it will be the convenient for the participants, those who can join at any corner from the nation or international, so they can take the benefit of any session. So we thought of to have this session on online mode, and very short period of time, good response we have received. Around 55 to 60 participants have already registered, and we really appreciate and thanks for the participants, those who have joined even today on the holiday, because with your response, because this topic is very much needed for all technocrats, all academicians. The progress of individual as an faculty or progress of any institutions depends on no copyright, patent, publications, and all this. And today we are with us renowned speaker, a resource person, Sheetal Dube madam, as well as two resource person from our own campus, Dr. Asif and Dr. Mirza Anwar. So we definitely ensure that today's session you will be definitely enjoyed, and there will be good output from this session, and question answer sessions also will be there, and you can raise your doubts, you can ask your questions, and you can enjoy this session. So with this, I would like to thanks director, deans, heads of the departments, all faculty members, and I appreciate the efforts being taken by Shaheen madam and her team to conduct this program on online mode. Thank you. Thank you very much.
Thank you so much, sir. Moving forward, it gives me a great pleasure to introduce our expert for today's, Ms. Sheetal Dube. She is a registered patent agent and currently serves as executive patents at Petlex Business Solution, a reputed knowledge processing outsourcing firm specialized in intellectual property services, competitive intelligence, and corporate training. The organization, the Petlex, caters extensively to the life sciences sectors, covering domains like pharmaceuticals, biotechnology, chemistry, Ayurveda, medical devices, etc. With over 300 patent filings and 85 plus granted patent, Petlex serve a wide spectrum of clients from MSMEs and startups to Fortune 500 companies, both in India and internationally. Their expertise includes patent drafting, prosecutions, patentability searches, freedom to operate analysis, and IP training programs. And Ms. Dube brings in-depth knowledge and hands-on experience in pharmaceuticals, chemical, herbal, Ayurvedic, and nutraceutical patenting. Her core competencies lie in prior art searches, patentability assessment, and translating complex scientific innovations into clear and enforceable patent specification. She is also actively involved in training, mentoring interns, and junior patent professionals. She holds masters in pharmaceutics from Dr. L.H. Hiranandani College of Pharmacy, University of Mumbai, and is known for seamlessly blending scientific understanding with legal precisions. Thank you, ma'am, for accepting our invitation even on holidays. And now our participants are excited to learn from your expertise.
Thank you. Thank you so much for the introduction. I can share my screen.
Yes, you can share. Yes, we can see. Can you just make it full screen? Yes, ma'am. Now it's visible.
Yeah. Good morning, everyone. So my name is Sheetal Dube, and today I am going to give you a basic idea about copyright and patents. Just a second. Uh,
Yes. Now we can
sorry,
see
sorry
the
for that.
changes. Okay. It's okay, ma'am.
Let's see what is intellectual property rights first. So, intellectual property rights are the legal rights granted to the individuals or the organization to protect the creation, invention, and innovation. So, basically, intellectual property rights are the legal rights. Intellectual property rights are the negative rights. Why do we say that it is a negative right? Because negative right means it exclude others from making, using, or selling that particular patented invention. For example, if you have a patent on a machine, only you can sell, only you can stop others. You have the right to stop others from making, using, or selling that particular machine, even if you do not manufacture it by yourself. So IP rights give you a negative rights. It also give you a monopolistic rights. What do you mean by monopolistic rights? So it is a right which gives exclusive authority to use or commercialize the patented invention. Legally, it creates a temporary monopoly so that you can so no one can exploit your invention without your permission. So, for example, if you have a patent provides 20 years of exclusive rights to a patentee, during this period, during this 20 years, no one can use the invention commercial, which gives a patentee a monopoly in the market. So, monopolistic rights are exclusive rights. IPR do not give you the right to commercialize. What does this mean? If you have a patented food product, but still you cannot legally commercialize it in the market unless you have a regulatory approval. If you get a regulatory approval, then only you can commercialize it. So we say that IPR do not give you the right to commercialize. It only gives you a right to stop others from making, using, or selling that particular invention. IPR can be sold like a property. It can be licensed out to others and even can be mortgaged for finances. One product can have multiple IPR, which means with one product can have multiple rights. Think of an example of a smartphone. A smartphone, the internal process and the technology can be patented, can be protected under patent. The outer appearance of the smartphone can be protected using an industrial design, whereas the internal software can be can be protected using copyright, and also the name of the brand or the logo can be protected using a trademark. So we say that one product can have multiple rights. Let's see what are types of IP. Types of IPR includes copyright, patent, industrial design, trademark, geographical indication, and trade secret. Today, our main focus is on copyright and patent. Let's see what is patent. Patents are the exclusive rights granted for an invention which allows the patent owner to exclude others from making, using, and selling the invention for a limited time. So patent gives you an exclusive rights for stopping others, not for you to commercialize, but for stopping others from making, using, or selling the patented invention. So patent typically lasts for 20 years from the date of filing. What all can be protected under patents is the new products or the processes, which means a new formula of a compound or a device or a process of preparation of a compound or a formulation. Basically, patents protects the functionality of the invention. Let's see what are the patentability criteria. There are 3 patentability criteria. If you want to get a patent for an invention, these 3 criteria need to be satisfied. The first one is novelty, which means the invention must be new and should not be previously disclosed in the public. Second is the inventive step, which means that the invention must be non-obvious to the person skilled in the relevant field. And third one is the industrial application, which means the invention must be capable of being made or used in the industry. Let's understand the 3 criteria for patentability with a food example. Sita's mango peel jam. Sita noticed mango peels are being discarded as waste. So she created a jam using only mango peels. Using her method, she not only removes the bitterness, but also retains the nutrients, and no need of preservative is required in the jam. So let's see if this invention is patentable, satisfying all the 3 criteria. The first one is the novelty. Is it new? Yes. Sita searched the patents papers, the research papers, and also the market, but nowhere where she can found that the jam using only mango peels was available using her method, which means that the invention is novel. The idea, the jam is novel. Moving on to the second step, that is inventive step, it is non-obvious. No, jam using mango pulp is already available in the market, so it makes it obvious. Jam from mango pulp is common, which makes it obvious, but using paste mango peels is not obvious. So to understand it, a jam of mango pulp is already there in the market, so it makes it obvious. But there is no jam in the market using the waste peels of mango. So it can be converted into non-obviousness. This also involves the second criteria, that is inventive step. Third one is the simplest one, that it has the industrial application or not. Yes, the jam can be made by the industry and also be sold by the industry. So all the 3 criteria, that is novelty, non-obviousness, and industrial application, are met by this invention. So we can say that Sita's mango peel jam is patentable. Let's see how to file a patent. No doubt the first step is patentability evaluation for the 3 criteria which we saw now. First one is the novelty, second is the inventive step, which is also called as non-obviousness, and third is the industrial application. If all these 3 criteria are met, then the further step is drafting the application. So the patent draft includes title, abstract, background of the claim, field of the invention, summary, detailed description, the working example, and the most important part is the claims. We have 2 provisions for drafting the application. One is the provisional application and second is the complete application. If you do not have the complete data, if your invention is ongoing, if you are formulating an invention, suppose if you are formulating a formulation and you have just reached the formulation part, you have to evaluate its characterization and also the evaluation. So we can go for the provisional one to claim the priority date, and then within 12 months, we can file a complete application. But if all the data regarding the formulation, its optimization, characterization, evaluation, all the things are ready, you can directly go for complete application. Once the application is ready, we will file the application in the relevant patent office. After filing, the application gets published within 18 months from the date of publication. If you don't want to wait for so long, for 18 months, there is one more provision called early publication. In that, the application gets published within a month from the date of filing. So you can also opt for early publication. For normal publication, there are no charges, but early publication comes with a prescribed fees. Once your application gets published, the next steps come the request for examination. If you want to take your invention till grant, then you have to file this form called Form 18A, Request for Examination. Once you file this form, the application will proceed to Patent Office and they will generate a report called First Examination Report, citing all the objections related to the invention, with the common objection includes lack of novelty, inventive step, non-patentability under Section 3, lack of clarity, conciseness, definitiveness, and all. To this first examination report, to this objections, we have to file a response called response to FER. In this response, we have to give a detailed argument regarding all the objections made, also provide the clarity, and amends the claim if necessary. Once this response is filed, and if all the objections are not resolved, then the controller may schedule a hearing. A hearing is an online video call conference. The applicant and the representative, the patent agent, the respective patent agent can join for the hearing, which is through an online video call. If all the objections are resolved, the patent will get granted. If the objection persists, there is a chance of getting a refusal. So it is very clear. The steps to file a patent: first is to evaluate it for patentability, then drafting based on the details you have, that is provisional or complete, then getting it filed. The publication stage, you can go for normal publication as well as for early publication. Then request for examination if you want to take your invention till grant. Once you file request for examination, then the patent office will generate an first examination report citing all the objections. Then we have to reply to that report, making a detailed FER response to FER. If still the objections persist, we may get a hearing, and then after hearing, we have to convince the controller. If all the objections are resolved, the patent will get granted, and if some objections still persist, it may get refused. You all guys must be aware of this YouTubers, the content creators, maybe not the faculties, but the students. Yeah. So these content creators or the YouTubers always have a fear of getting their channel demonetized due to copyright infringement. Let's see what is copyright. So copyright offers a protection for original work or authorship. Copyright protection affords. Hello. Yeah.
Yes, ma'am.
Did
Ma'am,
anyone?
you're audible.
Okay, sorry. Let's start with copyright. Yeah, copyright offers a protection for original work of authorship. Copyright protection affords the author of copyrighted work with specific rights that the author can give or sell to others or keep for himself or herself. What all can be protected under copyright? The novels, the poems, painting, drawings, the dramatic work, even the newspapers, computer program per se, films, sound recording, musical composition, also the choreography. Basically, copyright protects the expression of ideas, whereas the patent protects the functionality. I think my screen is visible.
Yes, ma'am, it's visible. You are on copyright page.
Yeah.
Yes.
So what does copyright apply to? It applies to an audio, literature, architecture, video films, choreography, music, even drama, pictures, graphics, and computer program. So we have a YouTube channel under the name of Pharma Literati. Most of the pharmacy students have visited this page. Basically, this Pharma Literati is related to a pharma related events, shares the pharma related events, news, courses, or contents. If you guys have not visited it yet, please do like, subscribe, and share the page. Now we saw what is copyright and patent. Let's see the significance of it. So copyright and patent encourages the invention to give legal protection, which provides legal protection, which boosts the confidence to create and invent. It motivates the individual to invest time and resource into the original work. It supports the research and the academics by safeguarding the student theses and faculty research. It promotes academic integrity and originality. It also promotes the commercialization. If you have an invention which is patented, you can license it out to a startup, an industry, and generate a revenue out of it. Having a patent or a copyright build an institutional IP portfolio which boosts the reputation, ranking, and funding potential of the institution. Coming up to the summary part, let's see what is the difference between copyright and patent. So, copyright is for the original literary, artistic, musical, dramatic work and software, but patent is for invention. It should be a product or a process. Copyright protects the expression of ideas, whereas patent protects the functionality, functional ideas or the invention. There is no registration for copyright is not mandatory. It is automatically granted upon creation. But for patent, we must file and get it granted by patent office. The duration for copyright is life of the author plus 60 years, whereas for patent, it is 20 years from the date of filing. Both copyright and patent are country specific, which means if you have filed a patent in India, you will have the rights limited to India and not to other countries. What are the rights granted for a copyright? So copyright gives you a right to stop others from reproducing, distributing, performing, or adapting your work. Whereas patents give you a right to stop others from making, using, or selling the invention. Copyright is for the original work, whereas for patentability, there are 3 criteria, that is novelty, inventive step, and industrial application. Example of copyright includes books, songs, software codes, and painting, whereas for patent, a new drug formula, machine, device, or a process for preparation. Who will have the author or the creator have the ownership in copyright, whereas the inventor or the assignee, that is, assignee can be an individual or an institution. The inventor or the assignee will have the legal rights for the patent. Public disclosure impact. If you want to copyright your work, but if you have already published it in a public domain, still you can protect your work using a copyright. But the same case is not with patent. If you want to get a patent, you shouldn't disclose it in any of the public domain. It will destroy the novelty. So first you have to get a patent filed and then only you can publish your invention. Just a second.
Sure, ma'am.
Knowing how to protect your ideas is as important as creating them. So please do protect your ideas and also keep creating them. Thank you so much for your patient listening.
Thank you, ma'am, for the insightful and the enriching session. We will now open the session for Q&A. If anyone has a questions related to IPR, patent or a copyright, please feel free to ask, or you can also post in the chat box. We'll give you 5 minutes for this Q&A, and resource person are there with us till end of the session, so we'll continue with Q&A at the end of the sessions also.
Hello, am I audible? Madam?
You are audible, Sharik sir, you are audible.
Yes. So, Sheetal, madam, in this
Yes.
interesting age of AI that we are living, and because there's a lot of generation of content that people are doing just with AI. This is basically called as synthetic data. It could be audio, video, a combination of all of them. How do you see protecting something like that which is being generated via AI? Let's say I generate something out of AI. Then how do you see? What are the challenges? What's your thoughts on that? Since that's a very evolving field,
So, sir, invention related to AI can be protected, but it should be within the criteria. The criteria which I have mentioned: the novelty, inventive step, and the industrial application. No doubt, novelty will be there, but the main step is the inventive step. It shouldn't be obvious. So, if you are if you're good to go with the inventive step, then I think it can be patentable.
Okay. So you haven't had any case or scenario situation where there was a clear expression that AI was involved in the process, and there are co-affiliations or joint ownership, something like that. Because this is a fairly common debate that is going on with regards to generation of IP.
Sorry, sir, but I didn't get your question. Can you please?
No. What I'm trying to say is, within your experience lately, have you had any
AI-related invention?
Yeah, AI-related, where AI was an equal partner in generating that IP, and are we going to recognize that officially as such? And if that, so what is the modality? I'm just curious about it.
Okay. So recently we had an invention related to some dental thing. But it was not patentable, as they have used an AI using a software. So basically, in patent, software is not patentable. Okay. Software cannot get a patent in India.
Okay.
And even if you combine a software in a hardware, then you can get a patent out of it. So I think related to AI, I have not come across till yet.
Okay. That's fine. Thank you so much.
Okay. Ma'am, there is a question in a chat box. How much from Shrishali, how much is costing for a patent filing and a grant process?
Okay, so the government charges, the official charges are different, and the professional charges are different. Srishali, you can just get connected with me, and I will be happy to tell you all the costing about the patent filing and the grant process.
Okay, thank you so much, ma'am. And there is one more question from Irfan Nalban, sir. What are prerequisites for the 18A form?
Okay, so as there is a form 18, which is request for examination, there is also a form called 18A, which is expedited examination, but it also has a certain criteria. Only the startup, MSMEs, government institutions, or one of the applicants should be a female. These are the prerequisites, few prerequisites for filing form 18A.
Okay. Thank you, ma'am. And there is one more question from Rajesh Narvade. Is there any time duration required in between filing and grant of a patent?
Is there any time duration required in between
filing and the grant of a patent?
Time duration, you mean to say the complete process, how long it will take?
I think so.
So there is no specific timeline for that. It completely depends on the patent office and the controller.
From Sushil, sir, can we patent the output of a software program? I think you have already answered for this, right?
Yes.
Okay.
What is trademark in
Dr.
IPR?
Ramzan Khatik sir, there's a question from Ramzan Khatik sir. What is trademark in IPR?
So basically, trademark is for logo, slogan, or the brand name which we file. For example, Apple have its logo, so that is the trademark for it.
Yes, yes, yes. So, ma'am, we'll stop a question answer here. We'll proceed with the other two resource person first. And meanwhile, you people can post your uh, uh, queries in a chat box. We'll have it at the end of the session. Thank you so much, ma'am.
Thank you.
Okay. So moving ahead, we are moving towards the experiences by our own faculties. Moving ahead, we are honored to have with us two of the gems of AIKTC. You can say Dr. Mohammed Asif Gandhi and Dr. Mirza Anwar Baig, who will now share their personal experiences and insight related to copyright and patent to guide and inspire our researchers as well as the participants. So, Dr. Mohammed Asif Gandhi, he is the associate professor at Department of Mechanical Engineering at AIKTC. Sir is an experienced academic and industry professional, currently serving as associate professor and the controller of R&D department of AIKTC. He had pursued B and ME in production engineering and had a PhD in industrial engineering from IIM Mumbai. He brings with him over 10 years of industry experience and 18 years in academia. He has an impressive portfolio that includes 10 patents, 6 copyright, and he authored 7 books and over 50 professional certifications. His dedication to research and innovation has made a lasting impact on both academic and the industry. Now I'll request Professor Asif Gandhi to please share his experience. Sir, first unmute yourself. Asif sir, could you please unmute yourself first?
Now is it
Yeah,
audible?
now audible, sir. Yes, yes. And thank you for accepting the invitation on holidays. Thank you, sir.
Yeah, thank you. Uh, uh, Thank you for giving me an opportunity to interact in this platform and also to express myself with my colleagues and all the attendees of the program. I have been associated with the institute since inception in 2011, and priorly, I was in industry for 10 years and in academia for around 17 and a half or 18 years. So during this time, uh, my main domain was related to production engineering, industrial engineering. So in due course of my academic journey, as normal academicians do, I was also inclined towards doing publications, finally, of papers in conferences in the form of books. And also, lately, I started doing a bit of patenting work also. And still, I'm not saying I've got proficiency in that. I'm still trying to learn more about that. So, since this is only an experience sharing session, I will give my point of view, how I went about doing it. So I have got experiences in writing papers for, initially I started with writing papers for presenting in conferences, and subsequently I mastered the art of writing in highly reputed journals, and then subsequently I also started writing books. So typically what happens in academia, we write a paper, for example, to submit in a particular journal, and typical response is like this: that can you make following changes in your paper, and can you modify it, or paper is accepted with minor change, major change. Assuming that you have catered to the needs of the publisher and responded positively, and finally your paper gets accepted, then what? The next step is that they say that we have accepted your paper for publication. Now you are expected to fill the following copyright form. Okay, now what is this copyright thing? Like, they want to do trading with the paper. They are the journals, right? So people are going to buy journals, they subscribe it. So that is that commercial part of it. So some publishers, they don't tell you to transfer the copyright of your paper in their name. and some journals they tell you. So this was my experience. So typically, what is this copyright transfer form? It consists of a single form like a thing in which you manually fill up. You say that my name is so and so. I'm the author of the first, second, or third author of the paper title so and so, and I'm staying at so and so place, and I'm transferring the copyrights of this paper title so and so in the name of so and so residing at so and so place. Then you sign that document, you scan it, and send it back to the publisher's office with a copy of the paper which they have accepted. So, so this is one simple process. Now, all publishers do not demand a transfer of your copyrights of your work. Sometimes they don't ask for it, sometimes they ask for it, and it can be negotiated also in some cases. So this has been my experiences in doing copywriting work. Then when it comes to doing writing papers, the another experience which I got was regarding book publication. Now, typically, the content is prepared by you, and you prepare most of the content and send it to the publisher's office, and they discuss with you what is your requirement. Like they discuss basic things like, do you want it black and white or do you want it colored? If it is colored, is it single color, double color, multicolor? Those type of issues. Because as the number of colors increases, the costing becomes more. And then they also say that how many pages of material is there. So the costing is directly related to the number of pages, the number of colors, and if at all you want better pages, the costing will go more. And so basically, they give some basic services free of cost, all the publishers. But if you want some additional services, see, they might also design the book cover for you. They might also make a draft copy and show you. If you like it, you can accept it, or if you want something different, you can request, no, please design something better. And sometimes they give you a choice that you can also design your own book cover and give it to them. So it works both ways. Okay, so the experiences which I got was that it was working both ways. They were ready to design and they also gave me a free hand to alter it if they want. So when it comes to books, now the content is yours, but designing part, formatting part, getting it registered with ISBN number, okay, making it a legal document, that is the help which you get from the publisher. And typically now in being academia, the experience which I got, so they typically they don't print on only one book. It's very costly to print only one book. So they will charge you something to recover the cost of what they have printed. And some publishers charge you, some don't charge you. Okay, some charge you, some people don't charge. Now, I'm talking of case of publishers who usually charge for getting the book printed. They could charge anything from 10,000 to 12,000 to 15,000. This is on the lower end of the range, assuming for a black and white book with normal acceptable quality pages. And in this, the scope of the work which is involved is that they will format your material. They will make appropriate changes to make it more appealing. They might design the cover. They might show you a draft copy. The legal regulatory page, which is there on the starting of the book, they will design. ISBN number, they will apply on your behalf. And finally, when the book is made, they'll also try to market it on various platforms like Amazon and Facebook and other media so that the saleability of the books increases. Sometimes in the process of this, in some cases, it is agreed upon that we will get royalty. In some cases, they don't agree to give royalty. But this, they make it clear right in the beginning. So royalty means some portion of the business which they make, they will give it to the author. Okay, so it depends on what type of arrangement has been made with the publisher. So in some cases, I got they said no, we will not be giving royalty. We will be simply publishing and publicizing your book. But in some cases, they say that we will give royalty to whatever sales that is paid. So this was regarding the experience of writing an authored book. Now there are two types of books. One is an authored book where there could be a single author, two author, three author, four author. So in a typical authored book, it looks like something like this. The cover page of the book has a title and how many authors are there, their names occur on the book, and maybe a publisher will have his logo and name written. Now when it comes to an edited book, okay, Now, an edited book, the book cover will have the name of the title of the book, followed by the editor's name, edited by so and so. It will not show on the cover page the authors who have contributed in writing various chapters. That will come in the inside section of the book or in the end of the book. I mean, they will do it very creatively, that everyone who has contributed in writing a particular chapter, single author or double author or more, it will be shown in one particular section. It depends from publisher to publisher. And there they will be writing about the author, say 10 lines about the author. So and so is working here, this is the experience, and this is his contribution in this particular book. So the individual chapters, most of the edited books, they are arranged in the form of individual chapters, and the chapters could be having single or multiple authors. And each and every author who has contributed, their name appears separately in a separate section of the book, either in the beginning or in the end, where a small brief biodata in 5-10 lines is written about each of them. So this is how the appearance of the authors will be there. In edited book, the editor's name will appear on the top and author's name will be inside. In authored book, the author's name will be on the top, and it could be one or more authors. And the remaining thing remains the same. In edited book, it is usually the copyright is of the editor only, the publisher. Whereas in authored book, sometimes it is with the publisher, sometimes it is with us. It depends upon the nature of the agreement or understanding done at the start of the publication process. So I talked about two things. One was my experiences in publishing papers and the copyright issues related with it. Other was about the edited and authored book. And then comes another experience in IPR was regarding the patents. Now in patents, I took quite some time to understand how the patenting activity is done. Basically, to put it in simple words, if we have an idea of how a particular design of a machine is there, for example, okay, and some device is there, and if we feel that nobody else must have designed something like this, okay, so either the product which we are designed or which have in mind, or the process by which it works, if we can put it on paper and in a paragraph, if we can explain how the design is and how it works, then that part you can make a claim that this is yours since it's original and nobody else has brought this to their notice. So if you are trying to claim that the design is original and it is or how the product looks like, then you can file what is called as a design patent, in which case you will have to show the drawing of the device or machine or thing which you have designed. And in order to make it clear, we will have to take photos of it or drawings of it from various angles and show it, so that people exactly understand what it is that you have exactly designed, and you are making a claim that this is a design patent, you are applying for a design patent. If you are not claiming over the design, you are simply claiming over the process by which it works, then you can file what is called as an idea patent, in which case you may or may not show the drawing, depending on if it's required to show a drawing to explain, you have to supplement a drawing, in which case you are making claim out how it works. So there could be two possibilities. You could design a machine and you could have two patents for that. One a design patent and one an idea patent. A design patent to tell that this design is original and this is how that machine looks. An idea patent to indicate that this is the way this machine works. This is how it works. So one product you design, but you can file for two patents, a design patent and an idea patent. So I have mostly done for in either one of them. Most of the patents which I have done, it was mostly in one of them. Now, I had resorted to the use of external agencies for help. So I didn't go into the legal aspects of it. That I left it to the patent agents. So now how many things you do on your own, it will save you money. And how many things you outsource, that much additional cost will be incurred. For example, if you want to draft the patent, if you are not able to do it in technical legal language, you might have to use the services of a patent agent, patent lawyer. And if you are able to draft it on your own, well and good, you won't have to spend on it. Similarly, drawing is there. If you are able to do the drawing on your own, you will save money. Otherwise, if you outsource that, it will cost. Similarly, to categorize your patent, if you should know what are the various categories under which you are going to file. If you know it, fine. If you don't know it, you will have to pay for it. So like this, how many things you do on your own and how many you outsource in that process, that could decide the costing of it. So anything from 3,000, it could go to a lakh also, depending on how many things you are managing at your end and how many you are outsourcing. So this is in brief my experiences in doing patenting of ideas, products, and that's all.
Thank you so much, sir. You have presented very well. You have shared very well your experiences with us. Now we'll open the session for Q&A for a few questions, and the rest question we'll ask at the end of the sessions. To
Yeah.
participants, you can ask your questions. Is there any queries?
Hello.
Yes,
Yes,
sir.
yes,
Yeah.
Rajesh, sir. Yeah.
Gandhi sir, how to decide price of the book? Who decides price of the book?
The experience which I had, the costing is decided by the publisher and based on their perception of the sellability of the book. But if you are strong enough, you feel that uh, you can manage it, okay, you don't give the copyrights to them, you decide the price. Mostly it is the publisher who decides because they are doing business. In academia, we mostly publish books for satisfying academic requirements and for personal intellectual joy. But it is the experience which I got. In each of the case, it was the publisher who decided the price of the book.
Thank you, sir.
Good, sir.
Yeah.
And sir, there is one more question in the chat box. How long may the royalty be operational by Professor Irfan Nalban, sir?
Pardon, can I get the question again?
How long may the royalty be operational?
Initially, it goes after at least 1 year or so. Yeah. Immediately it does not happen because these are lengthy processes. But afterwards, but they give, if they promise, they give. And they have a dashboard where they share with you that how many books were there. So my experience is they have shared, one of the publisher has shared a dashboard and says that so far this was the sales. Okay, so this is what is applicable to you. This is what is not better. At least for wait for, these are long-term things. That business becomes over a long-term period.
Okay. Sir, I have a small query that how you improved your writing skills or the drafting. Could you please share on it?
Yeah. So these things you don't get in books, but by a host of programs that I attended during my academic journey, and by collecting bits and pieces of information from various places where I attended programs. The people who express very well are typically people who write editorial columns of newspapers. So if we are in the habit of reading that, they have got the ability to summarize large number of pages just into one page. So they use very crispy language, no time pass, no verbosity excess. And if we got a habit of writing, reading, and speaking in that way, it is very, very effective. Secondly, is by listening to people like who are in uh, public domain, like for example, news, media, how they have the ability to summarize things and speak in short. Okay, so I constantly kept my eyes open to those people who have got the ability to summarize without missing out important content and still hitting the target. So typically, it is reading how various editors have given a summary, how the editorial column of a newspaper is there, because it's not easy to write an editorial column. They do a lot of reading before writing even one editorial column. And if you're in the habit of reading an editorial column, you will develop the ability to summarize in a very crispy manner, how to express your views in short. And secondly, when you're doing your PhD journey, they have a subject called research methodology. In that, they show you how to write a literature review. Okay, so literature review, people use this word in a very broad manner, but even if you know what is a literature review, but to summarize what you have read, that is still your original ability. So ability to summarize and inquisitiveness of what different people have written, but choose the best way to summarize. So some inborn skills are also there, but some skills have to be learned from experts like editors, editorial columns of newspapers. So I have read them almost every day. I read an editorial column of a newspaper. You must be knowing, madam, I come there and
Yes,
I always read summaries of books, the back section of a book when different people have given reviews. Some things we learn from editorial column, some things by reading works, people have given reviews of different authors on the back side of a book. I read that also. So the reason is not to know the content, the way they write, to summarize, because ability to summarize is the most difficult part, and that is what I try to learn constantly. Even today I'm trying to learn that. That's,
Yeah.
yeah.
Yes, yes, that's what I wanted you to share with my participants. Thank you. Thank you so much, sir. Now, moving ahead towards Dr. Anwar Baig, sir. Sir is an academician and researcher with over 17 years of teaching experience. He holds an M.Pharm in pharmacology and PhD from Nirma University with research interest in diabetes, toxicology, and scientific validation of traditional therapies. He has contributed significantly to the field of IPR with 2 patents filed and another one is in process. Wish you all the best, sir. You will definitely get a patented for this. And in addition to coordinating the M.Pharm program, he mentors the students, serve as a reviewer and editor for many international journals. Sir is actively involved in patent drafting and IPR awareness workshops. We are truly privileged to have such dedicated and accomplished professionals with us. So, sir, now it's over to you to present your experience to our participants. Anwar, sir, please unmute yourself. Yeah.
Hello, audible?
Yes, sir, you are audible.
Am I audible?
Yes, sir. You are
Hello.
audible as well as
Okay.
visible also. Yes, sir, you are audible.
Okay. Thank you so much, ma'am, for inviting me to this session. From the two session, most of the things are covered. So I'll try to share my experience by considering my patent in pharmacy, and basically I'll just try to highlight the points which will be relevant to the pharma students. Just to cover the few important points, I'll just share a few slides I have prepared, so it will be easy for audience to understand. As Asif Gandhi sir discussed, we academician, most of the time we are busy in the publications and we are not thinking about the publications of patents. So that was true for myself also. I was in the academic field from the last 17 years, but most of the time we are thinking about only publication. But during that process, we lost our innovative ideas. So from few years back, I was thinking about the patent, and then in last year we have collaborated with the Patlex team, and then we come to know that we have number of research projects and they are novel, and but we are not patenting it. So that was my experience sharing. So we have started with our B.Pharm project, just like madam. Is it visible? Slides are visible? Okay. So in last year, we have filed 6 patents in pharmacy. Out of that, 2 patents
So there is an echo sound in your voice. So your voice is not clear.
So I have filed a patent based on the herbal formulation. Like, okay. Hello.
Yes, sir.
Okay. Is it fine, ma'am?
Yes, now it's very much fine, sir.
Okay. So, ma'am, in last year, we have started with the publication of our B.Pharm projects. In that, I have tried to file a patent based on the polyherbal formulation. So during this journey, the important point was you have to start with the area of interest. You have to identify your own area of interest. So I have find out my area of interest and along with my student group. And then we have searched the literature. So that is very, very important. If you're starting immediately the research work without prior search, so it will be like a waste of time. So we have searched literature a lot, and then we come to know the gap which is available into the literature. And then simultaneously, you have to start thinking about the need of the research work. If there is a need, then only the novelty will come. So during this formulation, we have come across, we have seen all the marketed formulations, and we come to know that there is a gap in the formulation, and still there is a need. There is a need that the people want formulation for the digestive purpose, but still there is a lack of proper formulation. In case of herbal formulation, Ayurvedic formulations are available, but they are not properly standardized, and they are having technical knowledge. They are lacking technical knowledge. So we have tried to fill up that gap, and at the same time, as you can see here, we have developed a method. So again, the same point we have experienced. You have to go through the literature, and you have to see the available literature. If you are working at this stage, so you will surpass, or you will cross the three barrier of the patents. Okay, so we have prepared a protocol, and then we have we have taken the help of the expert from pharmaceutics department, because we are not expert in formulation. So we have taken the help of the pharmaceutics people, and at the same time we have taken help of the Sheetal madam. So she has converted that research work into a patent language, into the legal language. So my experience is that particularly for MPharm student, okay, you have to start with the innovative idea. First of all, try to identify your interest area, and then find out the research gap. And so automatically your work will be eligible for the patent criteria. In similar way, the second project we have completed, that is dark chocolate composition for enhanced memory function and gut health. So in similar way, we have performed, we have searched the literature, we have identified the need of the study, and then we have prepared a protocol, and we have taken the help of the expert from pharmaceutics domain, and as well as at the same time we have taken the help from the IP department. So like that, we have to go through, then only our patent will be in the form of patentable. Now the third patent, we are just about to file it. So it will be like a phytochemical enriched patent. So now in market, for but most of that. So they are not concentrating on the phytochemicals. So we have find out that gap, and then we have started working on that, and almost our work is it is about to complete. And the second point, the important point is you have to start early. If you are planning to complete the research work within 6 months, so at least you have to start before 6 months. So that time may be required for procurement of chemical. The time may be increased because of the trial and error. In pharmacy, we have to start with the trial and error. Most of the things will not be repeated as it is given in the research paper, but it will not get repeated. So that is one learning I have taken out from the last past experiences. As far as the challenges are concerned, so most of the time in pharmacy, a prior art search is one of the main part. Whenever you are filing a patent, so the main part is prior art. So before the start of the research, you should check the prior art. It may be in the form of a product, or it may be you can go for the Google patent search. Okay, so prior art is very much important. Otherwise, your patent will not be eligible for the patentable. If it comes under the prior art, so it will not be accepted. Just like in last year, we have sent almost 10 projects to Sheetal ma'am, and she has gone through all the patent art, and then out of that, she has selected only few projects. So that was my learning. Okay? Before the start of the research work, you should be going through the prior art first, and then only start with the your research work. Again, the important learning is while drafting the patent. So while drafting the patent, you should have some understanding of the legal language. So I have seen the patent draft. So lot of standard formats are there. As we are preparing in project report, so the format of project report and format of the research paper is totally different, and the format of a patent is totally different. So if you are filing by your own, so you have to learn the legal language. And again, timing of the patent is important. Just like we have filed a patent last year in August, I think so in August 2024, but still it is in the process. So meanwhile, you can work on the project, on the same projects, just like I have discussed with you the two projects. So we are working in M-Form on the same project. So it will be enriching your project. And at the same time, after filing the patent, you can go for the publication. So it will be like your project is intellectually, it is protected, and now you are going for the publication. So it will be a win-win situation. And again, as far as cost is concerned, so the cost, all the applicant, you should be ready to pay the cost. Again, as Asif Gandhi sir mentioned, you have to identify the area of your weakness. If you're not good in writing the draft, then you have to take the help. If you're not good in finding out, or you're not good in the giving the answers of the queries which were raised in the patent office, then you have to take the help. So that you need to find out cost and collaboration. And again, one important point is that I have experienced from the last few years is you have to collaborate. If you're collaborating, pharmacology. So if I want to have a good work or a relevant work in the pharmacy, so I should collaborate with the pharmaceutical. At the same time, pharmacognosy. So these are the two relevant fields. And sometimes we have to collaborate with industry officials. So that will be a group, and that group will deliver you a decent or a relevant research work. So that is one important learning that I have learned from the last session, last work. And again, the important learning is you should have a strong data. So for generation of the data, you should prepare a methodology, and that methodology should be supervised by the expert. If your methodology is improper, then the queries will come into the after the patent filing. So beforehand, you have to formulate a methodology, and at least you should attempt the important parameters, and that requires help from the domain experts. So that I have faced in the last project. And again, I'm advising to all the PG students just to think of filing patent before the start of your research, because most of the time we are not focusing on the patents, because we know that only one paper will be sufficient for the awarding of the M-Pharm or M.Tech. So we are not focusing on the research, we are patents, but it is very well. It's a practice. You make a practice of patenting it. Just I have discussed with you. We have 3 to 4 projects with us, and that can be patentable. But we have gone for the publication of the papers, and now that idea is already in the market. But still we are trying to file a patent by hoping that it is not already patented by someone else. So my advice to the PG student is you start thinking of filing patent at the start of your research. Try to find out the gap in the research and start early so that you can complete within the time frame. Otherwise, it will be half work done. Okay, just like in last sessions in BPharm students case, the students were not getting that much time. They are getting only 6 months. So I have extended the same project to a PG student. Now the PG student will be working on the same project, and that will be enriching the project. And at the same time, if there is a query from the patent office, so we will be able to solve the query. Okay, so ma'am, that's it from my side. I have shared my experience with you and all the audience. If is there any questions, so I can answer.
Yeah, sir. Now the session is open for the question and answer. Is there any queries from the participants? So then a small question from my side, as what you mentioned is that prior art. Could you please put a light on this? What is prior art?
Ma'am,
The
prior
question,
art is,
oh, even Sheetal ma'am can answer it. I don't have an
yeah,
issue.
Sheetal ma'am can answer better if she is there.
Yeah, she's there.
So basically, prior arts are like if you have an invention, a tablet, and we found a similar invention in the market. Okay, you have a research paper regarding that tablet formulation. That paper is called the prior art. You understood it?
Okay.
Okay, in simple, I will explain you in a simple word. अगर आपका कोई इन्वेंशन है, ठीक है, इन्वेंशन है आपका और वो आपने हमें इवैल्यूएट करने के लिए दिया, तो while evaluating it we will find the prior arts related, the similar arts related to the your invention. Those are called prior arts, which are already there in the public domain, so it is called prior arts.
Okay, you mean to say search on a particular topic, right?
Yes, the references you can
Right.
say.
Okay, fine.
Yeah.
Thank you so much, ma'am. Is there any other queries from our participants? Okay. So to summarize and reflect on today's, moving ahead, actually, there is no queries in the chat box even. So to summarize and reflect on today's learning, I now invite Dr. Sharik Sayed, Dean of School of Pharmacy at AIKTC, to share the key learning and reflection from today's session.
Am I audible, madam?
Yes, well, you are audible,
That's
sir.
great. Okay. So, first of all, I really like to thank you for scheduling such an informative session on IPR. I think it's very relevant in these days where IP generation has been into a lot of focus, especially with faculty being aware of that. We have a lot of master students. So, at the outset, I'd like to thank Sheetal madam. She's really walked us through with the basics of IPR patenting, which is sometimes very important to know in the totality. Sometimes we know in bits and pieces. So I think her session was very insightful, and she, very nicely clarified the entire process in a very simple manner. It would be good if she could share their slide deck with us, if at all possible. That would be a good repository for us for future references. And I think the pathway that she talked about, especially with regard to patents and copyrights, are very relevant for us as faculty members who are in the business of generating a lot of IP. So we should be aware of what kind of IP are we generating and how do we need to protect it in the right frame. Is it a copyright? Is it a patent? What else is there? That way, our intellectual effort gets protected, and to a large extent, if at all possible, gets commercialized as well. So I think, very relevant, and someone like me who has a very strong interest into AI and technology intersection. Lot of the future is going to be very challenging, especially because AI is coming into it. There's a lot of synthetic data that's going to come inside. But at the same time, what the field is talking about is originality and the newness, which sometimes with these big algorithms that are generating it lack it. So the human intellect and IP generation will still be valuable and still be very important in the future days. So in light of all that, I think Sheetal ma'am's session was very insightful. I really kind of learned a lot from it, refreshed some of my early understanding of it. And then we had these two rock stars from Khalsa Technical Campus, very own Dr. Asif and Dr. Anwar, sharing two different perspectives from field of engineering and health sciences. Very relevant experiences for faculty members and also a lot of master students who have joined this session. For them also, it's very important that they understand what kind of journey that they have taken, these two of them, and then how does that relate to their work that they are doing, understanding what they're doing, whether it's patentable or not, trying to get a handle beforehand rather than getting disappointed at the end of the journey that this is not patentable or this is not worth what they wanted to. So it's very insightful and it is very timely and appropriate. So I don't want to stretch it long, but I think that's how I would summarize. Very informative, very relevant with regards to real life sharing by both of them. So all in all, I think it was worth 1.5 hours of the time on holiday, but it was worth the time given the importance of topic. So that's it from my end, madam. I don't want to take much time. Once again, thank you to you also for taking this
Thank you
event
so much,
with
sir.
Salah.
Thank you. You
Thank you.
very well summarized the session in a very nice word, sir. Thank you so much for. Now moving towards the concluding part of Word of Thanks. Before that, if any participant would like to share their feedback, you are welcome. Anwar sir, could you please stop sharing the screen? Thank you, Anwar sir. Is there any now session is open for the participants? Would you like to share your feedbacks or?
I would be particularly interested in having any one of the students, master student, it could be MTech students or MPharm, to at least voice their learnings. At least if they don't have a question, maybe a line or two lines of their learning, and that would it
Yeah,
would be
true,
inspiring for her, and it will make the day for Shaheen madam as well, I guess.
true, sir. Okay, no issues, dear. We hope that you have learned good things by today's sessions. And now moving towards the concluding segment of our events, so we place to invite Dr. Fawaz Parker, sir, the head of Civil Engineering Department of School of Engineering and Technology, to present the vote of thanks.
Thank you, madam. Am I audible?
Yes, sir, you are audible.
Okay. So, good afternoon, everyone. It is my privilege and honor to propose the official vote of thanks on behalf of AIKTC Central Library and the IPR for today's wonderful, enriching, and insightful webinar on copyright and IPR awareness conducted in collaboration of World Book and Copyright Day and World Intellectual Property Day. First and foremost, our heartfelt gratitude to our expert speaker, Ms. Sheetal Dube, Executive Patent IPR Patlex Business Solution, for enlightening us with her valuable insights and practical knowledge drawn from her immense experience of over 300 patent filings and 85 plus granted patents. Your session was truly eye-opening and immensely beneficial to all the participants. We would also like to thank our esteemed faculty contributors, Dr. Asif Gandhi, Associate Professor, Department of Mechanical Engineering, and Dr. Mirza Anwar Baig, Associate Professor, School of Pharmacy, for generously sharing their experiences of book publication and the filing of patent and the journey with their journey with intellectual property. Your practical examples and academic contributions added value to the sessions. A sincere thank you to our librarian, Ms. Shaheen Momin, for organizing this meaningful initiative and making this event a success. Our gratitude extends to Dr. Rajendra Magar, IQC Coordinator and Dean SOAT, for his guidance and support throughout. We are also grateful to Dr. Ramzan Khartik, Director AIKTC, our own Mr. Burhan Haris, Honorable Executive Chairman BINM, and Dr. Zahir Kazi, President Anjuman Islam, for their constant encouragement in fostering a culture of awareness and innovation in intellectual property. Lastly, thank you to all the participants and attendees for your presence and enthusiasm, which truly made this webinar impactful. Let us take today's learning forward, recognizing that our ideas are intellectual worth. Let us protect them and use them to power our future. Thank you once again to all.
Thank you so much, sir. Now I'll request participant if you could switch on, unmute your video, so we'll have a group photo. E-group photo. Yes. Participants, if you could unmute your video, please. Thank you so much. Thank you. Thank you so much, team. Thank you, participants, for giving your holidays today. Thank you so much, everyone.
Thank you so much for your for the opportunity. It's been an absolute pleasure interacting with you all. Thank you once again.
Thank you so much, ma'am.
Thank you. Bye.
Bye bye, ma'am. Take care.
Yeah.
Have a nice holiday and happy Workers' Days to everyone.